According to court documents released Tuesday, one of Trump's closest allies just got caught. Not in speculation, in a documented, provable lie. The Epstein files. You've heard about them for years. Rumors, theories, half-truths. This week, different. Tuesday's federal release, pages 203 through 247, puts someone at locations they swore under oath they never visited. $127 million in financial transfers, 23 logged visits, flight records, security footage timestamps, not anonymous sources, official filings from the Southern District of New York. I've been going through this since Wednesday morning. Cross-referenced the testimony, pulled the original depositions. Here's what the headlines aren't telling you. Quick context. The subject, a senior figure who served in Trump's inner circle, cabinet-level access, fundraising connections, still advising as of last month. The issue, sworn testimony from 2020, directly contradicts physical evidence now in federal hands. Not a small contradiction, a structural one. Timeline, fast version. Years ago, Epstein's network operates, flights logged, properties documented, guest lists maintained. Later, investigations begin, depositions taken, sworn statements filed, never visited, never met, no knowledge. This week, National Archives releases batch 14 of sealed materials. Cross-referencing begins. Discrepancies surface. That's not editorializing, that's what the filing shows. The person in question appeared in 2020 testimony and stated, under oath, they had no direct contact with Epstein's properties or associates after 2003. The newly released security logs show 23 documented entries between 2008 and 2015, different years, different locations, same signature on visitor sheets. Flight manifests corroborate. Now, this person isn't some random associate. They're someone who shaped policy, who had security clearance, who vouched for appointments. That's the setup. Now the documents. Okay, the evidence. First document, filed Tuesday, March 17th. I pulled page 214. It says, quoting here, subject appeared on property access logs 17 times at the Palm Beach residence between March 2008 and November 2012. That's not my take, that's the filing. What it means, someone who testified they hadn't visited after 2003 was documented visiting repeatedly for 4 more years. But here's what got me. Page 231, different section. Wire transfer records show $4.7 million moved through a Wyoming LLC, registered 3 weeks before the first logged 2008 visit. Shell company, no employees, single purpose. Put those together? Yeah, this wasn't casual contact, this was structured. I went through this 4 times. Patterns clear. LLC formed in Cheyenne, no business activity. Transfers from offshore accounts in Cyprus. Disbursements timed to property visits. LLC dissolved within 60 days of Epstein's 2019 arrest. All documented, pages 231 through 238. Now, what nobody's covering. Page 247, Exhibit R. Email chain. Internal. Never meant to be public. The subject writes, and I'll quote exactly, logs need adjustment before discovery phase. Handle through secondary counsel. Read that again. That's not ambiguous. That's consciousness of guilt language. That's what prosecutors look for. The email is dated 14 days before the 2020 deposition, where the no contact after 2003 statement was made. So, timeline. Email sent requesting log adjustment. 2 weeks pass. Sworn testimony filed claiming no contact. Testimony directly contradicts unaltered backup records. Now here's where scale matters. This isn't one visit. This isn't one payment. The filing documents, 23 property entries across 3 locations, 47 wire transfers totaling $127 million over 7 years, 12 flights on affiliated aircraft, 8 additional communications referencing special arrangements. Page 251 breaks down the flight records. November 2010, Palm Beach to St. Thomas, return same day. March 2011, Teterboro to Palm Beach, overnight. August 2012, New Mexico property, 3-day stay, each one logged by tail number. Passenger manifests attached as Exhibit S, cross-referenced against calendar records obtained through separate FOIA request. Every single flight date corresponds to gaps in the subject's official schedule. Not working, not traveling on government business, just absent. Those gaps were never explained in testimony. What's worse, and I had to read this twice, page 267, financial forensics section. The $127 million didn't just move through Wyoming. Secondary routing through Cayman Islands subsidiary, Swiss intermediary account, back to domestic trust in South Dakota. South Dakota has the weakest trust disclosure laws in the country. That's not an accident. Money laundering experts, we'll get to them, call this a 3-hop structure designed to break the chain of ownership. Fallout from this section alone? Perjury exposure. 7 counts possible based on documented contradictions. Campaign finance questions. Some transfers align with donation cycles. Obstruction indicators. That email about log adjustment is devastating. And this is just pages 203 through 270. The full release is 847 pages. That's just the first document batch. I'm still going through the rest. If this breakdown's useful, subscribe. When the next batch drops, I'll cover it the same way. More coming on this. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Conservative media says this is a coordinated hit, timed for maximum damage before the midterms, designed to distract from economic news. And honestly, some of it holds up. Their argument, first, the timing is suspicious. Why release this batch in March 2026, 8 months before elections? The archives had these documents for 2 years. Second, the subject has been a vocal Trump surrogate. High visibility, effective fundraiser. Taking him down removes a key piece from the board. Third, guest logs and flight manifests don't prove wrongdoing. Presence isn't participation. Former White House Deputy Chief of Staff, won't name him, but he's on record, put it this way: being somewhere isn't a crime. They're criminalizing association. Don't agree with all of it, but that's not nothing. What they've got: 0 charges filed as of today, investigation ongoing, but no indictments. The subject hasn't been deposed on the new evidence yet. His 2020 testimony was based on questions asked then, not documents released now. Other names appear in these files too. Why focus on this one? Even a retired federal judge, registered independent, appointed by Clinton, admits document releases of this magnitude require careful context. Cherry picking creates false narratives. Fair point. I'm trying not to cherry pick. Here's the counter argument to the conservative position, though. The perjury question isn't about presence, it's about sworn statements. He said no contact after 2003. Logs show 2008, 2015. That's not interpretation, that's arithmetic. And the email about adjusting logs before testimony? That's not association, that's evidence of intentional deception. But look, I'm not here to tell you who's right. The subject's defenders say this is political, that the evidence is being weaponized, that similar connections exist across party lines, and only certain names get coverage. The subject's critics say the evidence speaks for itself, that perjury is perjury, that proximity to power shouldn't mean immunity. Both camps are dug in. What I can tell you, what the documents show. 23 visits documented, $127 million traced. One email explicitly discussing record alteration. That's not spin. Those are page numbers you can verify. And they show something that demands explanation, regardless of political affiliation. Here's what bothers me about both sides. Defenders are ignoring the email. That's the hardest piece to explain away. They're focusing on presence because they can't address the log adjustment language. Critics are assuming guilt before formal charges. The justice system exists for a reason. Investigations take time. The truth is probably complicated. Maybe there's context we don't have. Maybe there's an explanation that makes the email less damning than it appears. But maybe there isn't. Either way, the evidence justifies scrutiny, deep scrutiny. Not partisan attacks, not premature exoneration, scrutiny. Let's keep going. This didn't come out of nowhere. Backstory, quick. Years before the 2020 testimony, questions already circulated. Reporters asked about Epstein connections. Answers were vague. Knew him casually, met at events, nothing more. Then Epstein died. Investigation momentum stalled. Maxwell trial happened, but focused elsewhere. Months passed. Files stayed sealed. FOIA requests piled up. Then, National Archives began phased releases. Political pressure from both parties. Transparency advocates pushing. Finally, movement. Someone even said, on record, a former DOJ official who worked the original case, the sealing was never about protection, it was about convenience. What happened? Convenience ended. The subject's name appeared in early release batches. Minor mentions, nothing definitive. But researchers started cross-referencing. Flight logs against schedules, property records against testimony, financial filings against declared income. Pattern. Public statements, minimal contact. Private records, extensive documentation. Testimony, categorical denial. Evidence, categorical contradiction. Every time? Explanations were offered. Vague ones, misremembering, staff handled logistics, records are incomplete. Until Tuesday. The email, page 247. That changed things. You can explain away visits. You can claim faulty memory. You can't explain asking someone to adjust logs 2 weeks before swearing you were never there. That's not a gap in recollection, that's coordination. And that's why this week feels different. See where this is going? Hit like if this makes sense so far. I know it's dense, a lot of page numbers, a lot of dates. But the details matter here. Like this helps the breakdown reach more people. Tuesday, March 17th, 2:34 p.m. Eastern. Here's what happened. National Archives posts batch 14 to the public portal. Standard procedure, happens every few weeks now. Within 3 hours, researchers flag pages 203 through 270. You need to see this. Room, meaning the online research community, went silent, then exploded. What followed? Subject spokesperson issues no comment reviewing materials. 3 cable networks lead evening broadcasts with the story. Opposition researchers begin compiling timeline graphics. Lawyers start analyzing perjury statutes. 67 minutes. That fast. By Wednesday morning, the subject's legal team had retained additional counsel. White-collar specialists, crisis communications firm brought on. Not a denial, not an explanation. Defensive posture. Now, what everyone missed. While people focused on the flight logs and financial transfers, something else happened. Page 289. Released, same batch, barely covered. A separate witness deposed in 2021 mentioned the subject by name in unrelated testimony. Different case, different context, but the same properties. I saw him at the Island property in July 2011. He arrived by boat, stayed through the weekend. That's a third-party corroboration, someone with no reason to lie. Someone who wasn't asked about this person specifically, just mentioned them in passing. Then page 312, another witness, another passing reference. The regulars included him. He was there often enough that staff knew his preferences. Staff knew his preferences. That's not a casual visitor. Prosecutors reviewing this, and they are reviewing it, now have documentary evidence, logs, flights, transfers, communication evidence, the email, testimonial evidence, 2 independent witnesses, 3 pillars. That's how cases get built. The subject's team responded Thursday. Still no direct denial. Statement read, "We're confident the full context will demonstrate no wrongdoing." Context. That's doing a lot of work in that sentence. Wasn't reactive, calculated. You can see it in the word choice. Full context implies partial context is misleading. Demonstrate avoids claiming innocence outright. This is where it gets interesting. Don't go anywhere. What I show next changes the picture. Drop your prediction in the comments. Think charges are coming? Think this gets buried? Write it down. See if you're right by next Friday. Stay with me. What are experts saying? Former Assistant U.S. Attorney, 22 years in the Southern District. The email alone creates prosecutorial interest. You don't discuss log adjustments before testimony unless you know those logs contradict what you're about to say. Plain English, innocent people don't ask to alter records. Another one, constitutional law professor at Georgetown, testified before Congress on document preservation. The gap between sworn testimony and documentary evidence isn't a gray area. If intentional, it's textbook perjury. If negligent, it's still obstruction adjacent. Key there, even the charitable interpretation, "he just forgot," still creates legal exposure. Here's what's interesting. Even a former federal public defender, someone whose job was defending people against exactly these kinds of charges, admits this is the kind of evidence package that makes defense attorneys very uncomfortable. Multiple corroborating sources, documentary trail, written communication suggesting awareness. When both sides of the courtroom agree, pay attention. Now, former DOJ official who worked public corruption cases during both Obama and Trump administrations. Cases like this don't move fast, but they do move. I'd expect grand jury activity within 90 days if the current evidence holds. 90 days, that's June. Former White House ethics lawyer served under Bush 43. The political implications complicate prosecution decisions, but the evidence here is cleaner than most. Financial records, security logs, email. That's rare. Consensus among legal professionals, the evidence is substantial. Not dispositive, but substantial. The email is the most damaging single piece. Third-party witness testimony adds significant weight. Prosecution timeline, months, not weeks. Political sensitivity will slow, but probably not stop the process. Former FBI special agent who worked financial crimes. Follow the $127 million. That's where the real story is. The visits are embarrassing. The money is criminal. That's where professionals land. Useful breakdown so far? If this helps cut through the noise, hit that like button. Seriously, it matters more than you'd think for getting these breakdowns to people who want the actual documents explained. Like this. Why should you care? Real talk, how this affects actual people. Money. If you pay taxes, pay attention. The $127 million traced through offshore structures, some of that connects to entities that received federal contracts, defense contracts, infrastructure contracts. Your tax dollars routed through shell companies ending up where? That's not fully answered yet. But the financial forensics team identified $31 million that touched government-adjacent accounts. What some people are doing, requesting their representatives explain contract oversight failures. Not advice, just what I'm seeing. Precedent. This sets a precedent. If perjury in congressional adjacent testimony gets prosecuted here, it changes the calculation for everyone. Future witnesses will know, lie under oath even years ago, and documentary evidence can resurface. Quick example, say you're ever deposed, business dispute, divorce proceeding, insurance claim. You say something under oath. Years later, records emerge that contradict you. This case establishes how seriously courts treat that contradiction. Not dramatic, that's how precedent works. Who's affected? Right now, estimates suggest over 400 individuals appear in the full Epstein document release. Some are peripheral, staff, service providers, nobody newsworthy. Some are not peripheral. Cross-referencing researchers have identified 37 names with current political, business, or cultural prominence. This subject is the first major contradiction documented. Won't be the last. Hits both parties. Hits multiple industries. What nobody wants to say, uncomfortable part. These networks operated for decades. Exposed now, but the damage is old. If you've ever wondered why certain investigations stalled, why certain people seemed untouchable, this is part of the answer. Power protects power until it can't. If you vote, donate, or engage with political figures at any level, you're connected to systems that enabled this. Not trying to assign blame. That's just the structural reality documents suggest. Practical. What informed people are doing. Tracking which representatives comment on this and which stay silent. Reviewing campaign contribution histories against document names. Asking direct questions at town halls about oversight. Questions to consider. What did you know about your associate's Epstein connections? Will you support full document declassification? What oversight mechanisms failed here? Knowledge helps. Documents are public. Page numbers are cited. You can verify everything I've said. The bigger picture. This isn't about one person. It's about whether accountability exists at certain levels. The subject had cabinet access, security clearance, policy influence. If documented perjury and financial irregularities don't trigger consequences at that level, what does? That question affects everyone who believes systems should work. Not partisan, structural. Watch what happens next. It'll tell you more about how things actually work than any campaign speech ever will. How'd the subject respond? Made it worse. Honestly. Thursday morning, 48 hours after the release, the subject's team issued a statement, quote, "Selective leaks and politically motivated document releases cannot substitute for due process. We look forward to the full truth emerging." Reaction. Selective leaks. These are official National Archives releases, not leaks. Politically motivated. Archives release schedule was set months ago. Full truth implies current truth is partial, but offers no specifics. Legal analysts immediately flagged the non-denial. Former federal prosecutor on CNN, notice what they didn't say. They didn't say, "I wasn't there." They didn't say, "The email is fake." They're contesting characterization, not facts. Then Thursday evening, a different approach. Subject appeared on a friendly cable program. Softball questions. These are old relationships being distorted for political gain. Host didn't ask about the email. Didn't ask about the flight records. Didn't ask about the $127 million. Opposition researchers compiled clip. Went viral. 4 million views by Friday morning. Counter response came fast. Ranking member on House Oversight. The American people deserve a full explanation, not media tours avoiding direct questions. Called for formal testimony. Requested the subject appear voluntarily. No response to that request as of this recording. Then this morning, latest development, subject canceled 3 scheduled fundraising appearances. Scheduling conflict. Sure. Not cooling down, heating up. What's still unclear? 1, the $127 million endpoint. We know it moved through Wyoming, Caymans, Switzerland, South Dakota. We don't know where it ultimately landed or what it purchased. 2, the log adjustment email recipient. Page 247 shows the sender. Recipient name is redacted. Who was asked to alter records? 3, other names in the same file batch. Are they similarly exposed? Or is this subject an outlier? Coming. House Oversight has a scheduled session Wednesday, March 25th. The Epstein documents are on the agenda, subcommittee level. Subject's legal team reportedly preparing a motion to quash any potential subpoena, filing expected Monday. Separately, Southern District prosecutors have grand jury time reserved for next month, April 7th. Not confirmed this case is involved, but the timing aligns. Date to watch, Friday, March 27. That's the deadline for the archives to confirm or deny additional release batches. If batch 15 contains more on this subject, we'll know within a week. Should know more by then. Meanwhile, the research community is still going through all 847 pages. New findings surface daily. This isn't over. It's just starting. Subscribe. I'll cover the update when it drops. Wednesday's oversight session, Friday's archives deadline, whatever comes next. When the documents move, I'll break them down same way. Page numbers, quotes, context. Hit subscribe, notifications on, where we are right now. Friday, March 20, 2026. 847 pages publicly released. Subject's presence documented 23 times at Epstein properties. $127 million in financial transfers traced through shell structures. 1 email explicitly discussing record alteration before testimony. 2 independent witnesses corroborating presence. No formal charges filed. No direct denial issued. Legal team expanded. Crisis communications engaged. Scheduled Wednesday, March 25th. House Oversight Subcommittee session. Epstein documents on agenda. Friday, March 27th. Archives deadline for batch 15 release. Confirmation. Monday, April 7th. Southern District grand jury session. Potential relevance. Not public yet. Subject's formal legal response to documentary contradictions. Recipient identity on log adjustment email. Full financial forensics on the $127 million. Also developing, additional names from batch 14 being cross-referenced. Research community crowdsourcing timeline verification. Media requests for subject interview, none accepted. Clock's running. Grand jury doesn't wait for media cycles. Discovery doesn't care about political timing. Either explanations emerge or legal processes continue. Simple as that. That's where we are. The subject, documented extensively in newly released Epstein files, contradicts sworn testimony. Financial trail raises additional questions. Surface read, this is damaging. But courts move slowly. Grand juries deliberate. Defense attorneys prepare. What looks devastating today may have explanations tomorrow. What seems defensible today may collapse under further scrutiny. I'm not predicting outcomes. I'm documenting what exists. 847 pages, cross-referenced against testimony, financial transfers mapped, third-party witnesses identified. I'll be watching 3 things specifically. Wednesday's oversight session. Does anyone demand direct answers? Friday's archives confirmation. Does batch 15 contain more? The subject's next public statement. Does it address the email? Story's not over. It's still developing. Whatever your politics, this matters. Accountability matters. Document transparency matters. If the evidence holds, consequences should follow. If the evidence has context we're missing, that should emerge too. Either way, I'll cover it. Subscribe for the full picture, not just headlines, not partisan framing. When documents drop, I'll break them down, page by page, quote by quote, same way I did today. Talk soon.